believe this came up during the, the clash with the public defender's office, but where they had said that in certain instances you would tell the client sitting right there that the lawyer was not acting in their best interest.
I don't think you can say that occurred on more than one occasion.
Was it just the one? Okay, I'm not trying to.
Yeah, no, and
answer,
on
but
that
I just
occasion, what had occurred was extraordinary. The client was a person, the defendant was a person who had more experience with the criminal courts than anybody else in the courtroom, with the possible exception of the clerk. I was very concerned. It was a revocation of probation. I was very concerned when I modified probation that the client was going to think that I had done it because I was displeased with his attorney. And I wanted to make it clear that that wasn't the reason. I said, yes, I think your lawyer did a bad job. That's not the reason that I'm doing this. I'm doing it because of what you did or didn't do on probation.
I just have a general question about an incumbent, particularly running in a race against people who are not incumbents. What do you think is the best way, both for us and for our audience of lawyers and just for the general voting public, to measure a judge's performance? Do you think they should look to the opinions of lawyers who've been before you, or the opinions of just the litigants themselves, or your reversal rate, or what do you think is a fair way to assess that?
Certainly the reversal rate would be one thing. The judgment of others would be important. I have the endorsement of 5 members of the California Supreme Court. I have the endorsement of 13 members of the Court of Appeals for the First District. These are judges who, particularly the Court of Appeals, see my work all the time, who have the pleasure of reading transcripts of my trials and judging whether the decisions that I make are appropriate, are fair, are just, are correct. When those justices give me their endorsement, it means a lot. I also have the endorsement of the overwhelming majority of the members of my court. They don't see my work. Mm-hmm. They work with me.
Just to play devil's advocate, could the voters say, well, the judges always support each other, they're looking out for each other so that someone won't challenge them in the future?
Yeah, that's a fair comment with regard to my colleagues, the Superior Court judges. It doesn't pertain to the Supreme Court or the Court of Appeals.
So you feel the appellate endorsements carry more weight?
They see my work. They're not under the same potential for challenge. As you know, they have retention elections every 12 years. Occasionally those are contested, but it's a much, much different process.
Should the voters have any concern about the endorsements and the funding sources for Supervisor Sandoval?
Well, if you look at the endorsements, the list that I've seen, there are precious few lawyers on that list. There are a lot of politicians. It's an interesting question that the voters have to decide as to whether or not the leverage that an active politician has in technique, in fundraising, is appropriately employed in running for a judicial office. We are developing in this country more and more questions about how well political campaigns and judicial positions fit together. and I'm sure you've been following it closely. There's no easy resolution to that question, because beyond doubt, this is an honest-to-God election that I'm in, with the demands that an election imposes on everyone. But I am extremely sensitive to, number one, not behaving inappropriately, not endorsing candidates for non-judicial office, not endorsing ballot propositions, abiding by the canons that bind both me and the candidates who are seeking this job, about being very clear about who is contributing to my campaign and the disclosures that I will make about that in the future when it's a lawyer who comes before me. Those are my concerns.
What kind of campaigning do you think you'll be doing for the job?
As effective as possible. The options still haven't been finalized. The choices finally haven't been made. I rely on the consultants for the campaign that I have, in whose judgment I have great confidence, and in whose ability I am totally sure to decide how best to allocate the resources that are available. But it is a daunting job to try to communicate with 100 to 200,000 potential voters.
Do you expect to go to meet with groups of people and
I've been
informal
doing that.
settings and
Sure.
things like that?
I've been doing a great deal of that.
Mm-hmm.
The more broad approach through mass media techniques is what remains. And when you're talking about that size of an electorate, the personal touch isn't always possible, particularly when you've got a full-time job doing something quite different.
Mm-hmm.
So it's a challenge. It's certainly stimulating.
Are you troubled by the fact that Gerard Sandoval has raised a lot more than you have?
Oh, it certainly has my attention, and it has the attention of the people who are helping me raise money. As your article strongly suggested, and Mateer and Ross suggested as well, it provides a real stimulus.
I want to ask you a question about one of the issues going on in San Francisco's courts is that there's a backlog of trials, mostly coming from the heavy volume of misdemeanor and felony trials being handled down at the hall. As a member of the court, do you have any thoughts about sort of what that backlog is being caused by and how best to fix it?
Well, I think the analysis, and the court has done a lot of it, the analysis shows that the issue really isn't felony trials causing a backlog. It's the misdemeanor trials that are causing the backlog. And we need to work very hard at addressing those problems. Start with the proposition that someone charged with a crime has a right to due process, which includes a trial by a jury of his peers or her peers, if that's what he wants. You have the undeniable fact that if everyone wants a trial, we can't accommodate it. Not with 50 judges, not with 100 judges. And therefore, means of resolving those cases prior to trial are extremely important.